polity series we are discussing today anti-defection law. Okay, so what is anti-defection law? Let's start. See, again, it was introduced in by the 52nd Amendment Act of 1985, but it was modified in the 2003 by the 91st Amendment Act. Okay, there was one change. It 91st Amendment Act introduced 10th schedule as well as is removed the disqualification on the ground of defection not to apply in the case of split by 1/3 members. Okay, so these are the points that we will discuss in today's video. Okay, so first, see provisions of the act. See, what about the members of the political parties? See, if a particular member vote against the political party's agenda, okay, so then he can be removed from the party, as well as he has to vacate his seat in the House of Parliament. Okay, either of the House of the Parliament. If he is member of the Rajya Sabha or he is member of the Lok Sabha, then he has to vacate his seat if he vote against the what is the party's whip. Okay, so these are the powers. This act doesn't this act talks about these things only, to how to remove a particular candidate from his seat. Okay, so again, next point is if he vote against the party, okay, then before voting he has to take a permission. Okay, if it is necessary for him to vote against the party, then he has to take permission of the party, or he can the party can decide, if party gets to know that a person is voted against the party's wish, okay, then the party can take that action on that guy for like after 15 days. Okay, in between 15 days also the party can take action, or but before the action the candidate can approach the party and take its permission. Okay, so what about the independent member? Again, see, independent members if join a party after getting elected, okay, then he will be disqualified. Okay, a person like let's assume like there is a person X, okay, then he contests a seat independently and he wins that seat, and then he goes to parliament. Okay, and after going to parliament, then if he thinks that he should join big political party like BJP or Congress, then if he joins that party, then he will be disqualified. Why? Because he has contested election independently, so he is betraying the voters that voted for him. Okay, they voted for him because he was independent, but after getting elected, if he is joining the party, then clearly something is wrong with it. So that's why there is this provision included in this act, is that a person if joins a party after getting elected as an independent member, then he will be disqualified. Then what about the nominated member? See, remember, the Rashtrapati appoints the nominated member in the Rajya Sabha as well as in Lok Sabha. Okay, so then what happens if a particular persons join a particular party? A particular person gets nominated by the president in the Rajya Sabha, let's say, and after getting nominated as a Rajya Sabha, then he thinks that he should join a party, but after 6 months if he thinks to join the party, then, and if he joins the party after getting selected, nominated in that particular house, after 6 months he remains independent in that particular house, and after 6 months if he thinks that he should join a particular party, then just because he joined the party after 6 months, that's why he will be disqualified. Okay, so let me tell you one thing, that if a particular person, okay, like Sachin Tendulkar, okay, he gets nominated in the Rajya Sabha. Okay, so if getting nominated, let's say he gets nominated today and he joins the parliament tomorrow. Okay, so day after tomorrow you have to count 6 months. Within these 6 months, if he joins a political party, a particular political party, any political party, then he is okay. Okay, he will not be disqualified. But if he joins a particular party after 6 months, okay, then and then only he will be disqualified. Okay, so remember that this is the difference between independent member and nominated member. Independent member cannot join the party at any given time. Okay, whether he has he cannot there is no such a provision that he can join a party after 1 year or 2 year. No, there is no provision, so he can't join the political party, any political party. But a nominated member can join a political party before completion of his 6 month, okay, in that particular house. Just remember that this is something confusing, and you might expect a question on it. Next point, again, what are the exceptions? Okay, so there are some exception in this anti-defection law. What are those? See, merger of a party means what? Like Prajarajyam was a party of Chiranjeevi, okay, in Andhra Pradesh. Yesterday's Andhra Pradesh was there, and in that there was a Prajarajyam party by the Chiranjeevi. Then that party got merged with the Congress party, okay, Indian National Congress. See, remember now, what about the members of that political party who are also a member of the any of the house of the parliament? Okay, what happens with them? No, there will not be any disqualification of those people, okay, because the complete party was merged with the another party, so there will not be any disqualification. Next, the two-third rule. What does that mean? See, if particular let's say a Congress is going through a bad patch nowadays, okay, so a Congress, if two-third member of the Congress decides that they should resign from Congress and join BJP, okay, then what will happen? That at that time these members will not be disqualified, okay, from the seat of their seat in the Lok Sabha or Rajya Sabha. See, at that time the party high command of that particular party, let this was Congress, okay, so they cannot disqualify them because two-thirds of the they have majority, okay, two-thirds of the members wants to join another political party, so they can't disqualify them, okay. But see, there was a previous rule was of one-third rule, okay. So what that means is, like, if one-third of the members decide to join a political party, then they cannot be disqualified. That was the earlier rule, but now they have added one-third more. That means if you want to not to get disqualified, okay, from particular party and your seat, then you should have two-third of the majority. Like a particular party, the members of that particular parties should be in majority to join another political party, or even abandon any party also, okay. This is also included in that rule, okay. So remember this, that two-third rule is there right now, one-third rule is scrapped, okay. Next point is, who is the deciding authority? Again, presiding officer of the particular house will decide whether the disqualified member is disqualified or not, okay. Again, there was a SC ruling on that. See, Supreme Court can intervene. Why and how? See, Supreme Court argued that presiding officer acts as a tribunal in the case of discussing the matters of disqualifications, and as per the constitution, every tribunal comes under the Supreme Court, okay. So Supreme Court can preside over the presiding officer of that particular house, okay. Remember that was the rule they have come up with, okay. So Supreme Court can intervene, can decide the matters of disqualification of the particular member, okay, or particular house. Remember that this is something that they are going to put that in the options, so you remember that Supreme Court can intervene in the disqualification process. Next point is, this disqualification has no immediate or automatic effect. What does that mean? See, immediate or automatic means there will be a due process that they will follow, okay. That if particular member gets if you have to decide whether that particular member should be disqualified or not, then that matter will go to the first to the presiding officer. Then presiding officer can refer that matter to the committee of privileges. Then that committee of privilege will scrutinize that matter. Then presiding officer will give time to speak to the members whose case is been discussed, okay. Then the member will discuss will put his thoughts in front of the house, and then only they will decide whether to disqualify that person or not. So that means this process is not immediate or automatic. They have to follow some protocols, they have to interrogate the matter, and then they will decide. Okay, so remember that. Next point is very important, 91st Amendment Act. As I told you earlier, 10th schedule was introduced in the 91st Amendment Act. The 1/3 rule was scrapped in the 91st Amendment Act. And second thing is that they have decided this 91st Amendment Act talks about the strength of the minister in the particular government. Okay, so if there is a central government we are talking about, then central government's ministers, total minister in the central government cannot be exceed the 15% of the total strength of the Lok Sabha. Remember that. Okay, so if there is a 100 members in a Lok Sabha, okay, then maximum number of ministers in the central government should not exceed 15. Okay, remember that. This means 15 more than 15% of minister you cannot appoint. Okay, so again, if a person gets disqualified from the particular party, then he ceases to be a minister, or he cannot hold the office of profit under the government. Okay, so remember that. What about state then? See, state also has the same rule, like a state also cannot exceed the total number of minister in the state government more than 15% of the total strength of the legislative assembly. Okay, so remember that if a particular assembly has 100 members, then the more number of members in that particular, the number of ministers in that particular what we will say, the state government should not exceed than more than 15. Okay, and there is a minimum rule also in case of state government, that in a state government we have to have minimum 12 minister including CM. Okay, minimum 12 minister you have to have, but there is no such rule of a minimum minister in the case of central government. Central government can even have 2-3 minister also, but in case of state government there is a rule that state government should not must not have members less than 12. Okay, so remember that ministers minimum ministers number is fixed in the state government, and maximum numbers is also fixed in the state government. But in case of central government, there is no limit on minimum number of ministers, but there is a limit on maximum number of minister in the particular central government. Okay, remember that. Again, if a person is disqualified in the state government, disqualified from his party in the state government, he cannot be a minister, as well as he cannot hold office of profit under that particular state. Okay, remember that. So thus we have concluded this anti-defection law and 91st Amendment Act. Thanks guys for watching this video, and we will meet in a next video. Peace.